Hello people, today we are going to discuss a recent Supreme Court judgment, that is LAXMIBAI CHANDARAGI versus State of Karnataka. This case was decided on 8th February 2021. Let us start by understanding the facts of this particular case. In this case, Mr. Basappa reported that his daughter, Mrs. LAXMIBAI, is missing since 14th October 2020, and this report was made at Murgaon Police Station. In response to this particular complaint, a missing persons first information report was filed, and the investigating officer gathered the missing person's parents and relatives' statements. After collecting all this information, it was quite evident that LAXMIBAI was in contact with Mr. Santosh Singh Yadav. In this case, LAXMIBAI is petitioner 1 and Santosh Singh Yadav is petitioner 2. Santosh Singh Yadav is an M.Tech from NIT Tiruchirappalli and LAXMIBAI is a MA B.Ed. Santosh got placed as an assistant professor in Jain College of Engineering in Karnataka, while LAXMIBAI was a lecturer in Karnataka Lingayat Education Society Pre-University College. And in the course, they fell in love with each other during their assignments. During the course of investigation, it was discovered that LAXMIBAI and Santosh travelled from Hubli to Bangalore and then to Delhi through Bangalore without informing LAXMIBAI's parents, and then they went to marry each other. LAXMIBAI told her parents about her marriage by sending them a marriage certificate via WhatsApp on 15th October 2020. Considering the missing complaint that was filed, the investigating officer went to Ghaziabad, where LAXMIBAI and her husband Santosh resided, and demanded that LAXMIBAI should appear at Murgaon Police Station to provide a statement that she was married to Santosh so that the case can be concluded. This was followed by an incident where LAXMIBAI wrote a letter to the investigating officer indicating that she was married to Santosh, and due to imminent threat from her family members, she would not be able to visit the police station at Murgaon. Even after this, the investigating officer did not close the case, and he said that if LAXMIBAI did not return to Murgaon, they would file a kidnapping case against her husband. Aggrieved by the investigating officer's remark, LAXMIBAI and her husband filed the present petition before the Honorable Supreme Court under Article 32 of our Constitution, claiming that she was subject to dual jurisdiction because she lived with Santosh in Uttar Pradesh while she was basically from Karnataka. They told the court that they were being threatened by LAXMIBAI's uncle and even sought protection from Allahabad High Court. But the petition could not reach the board for an urgent hearing even after pressing for it for approximately a month. So, the issue of law in this case was whether the FIR should be quashed because both parties consented to marry at their own will or not. So, in this case, the apex court stated its dissatisfaction with the way the investigating officer handled the whole investigation, and the court even stated that if the investigating officer could have visited the residence of Santosh, he could have recorded the statement of Lakshmi Bai at the place where the petitioners were residing, rather than insisting and calling upon the petitioners to come to the local police station at Karnataka, thereby delaying the investigation. Further, the investigating officers moved to threaten Lakshmi Bai with false charges on her husband Santosh if she did not come back to Karnataka was also disregarded by the apex court. The court further stated that Lakshmi Bai's marriage certificate and her chat with the investigating officer concerning her safety in returning to her hometown, and even when she said that she is not missing and is living with her husband, is clearly demonstrating the truth of the issue. The court even emphasized on the fact that an officer can record the statement wherever the subject feels free and secure, rather than imposing coercion that their statement would only be recorded if they are accompanied to a specific police station. The court even relied on the case of Shakti Vahani versus Union of India, which is a 2018 case law. The bench also stated that any person's matrimonial affairs are covered by the right to privacy, which is now a basic right under Article 21, following the Supreme Court's judgment in the case of K.S. Puttaswamy versus Union of India. Article 21 guarantees the freedom to choose one's life partner, which is the most intimate of all the rights that make up personal liberty. The court further stated that intimacies of marriage lie within a core zone of privacy, which is inviolable, and even matters of faith would have the least effect on them. The right to marry a person of choice is therefore held to be integral to Article 21 of our Indian Constitution. Therefore, the FIR against the petitioner was ordered to be quashed and the present writ was disposed of with the hope that the parents of Lakshmi Bai will willingly accept her marriage and would re-establish their relationship. Thank you.